Okay. Welcome everyone to the Judiciary Committee hearing this Thursday morning at 9:15. I'll go through the now required opening statement so that everybody knows what happens if we have a computer breakdown. This meeting, including the audio and video of remote participants, is being streamed live on YouTube. You will find links to viewing options for all Senate meetings on the live and on-demand video page of the legislature's website. In the unlikely event that we have to abruptly end this hearing due to major technical difficulties, the committee will reconvene to discuss any outstanding business on Tuesday, February 9th at 9:25. February 9th at 9:25, and a public notice will be posted on the legislature's website. For the people testifying remotely, all testifier audio will be muted and video disabled until it is your turn to testify. There's a 2-minute limit, and there's a counter that you can watch as you go along. If there are temporary technical glitches during your turn to testify, we may have to move on to the next person due to time constraints. We'll try to come back, but we appreciate your understanding and remind you that the committee has already received your written testimony. I'll be reading a list of people who submitted written testimony for each measure. We apologize if the closed captioning doesn't accurately transcribe the names. If you're interested in reviewing the written testimony, please go to the legislature's website, www.capitol.hawaii.gov. You'll find a link to testimony on the status page for the measure. Members, please, we're going to do it the usual way, ask questions at the end. And I believe that's all we have for the opening remarks. Okay, let's see. First up today is SB 18 relating to taxation would establish an empty houses conveyance tax against certain residential property owners who own a vacant residential unit in the state. First up on this measure is Isaac Choi, Director, Department of Taxation, or his designee.
Good morning, Chair Rhodes and members of the Senate Judiciary Committee. Tenshiro Ichi for the Department of Taxation. And we stand on our written testimony providing comments.
Comments, okay, thank you.
Thank you.
Next, we have Janine R. Udui, Deputy Attorney General, with comments. Denise Isari Matsubara for Hawaii Housing Finance and Development Corporation, also with comments. Ken Haraki for the Hawaii Realtors in opposition. Neil Okabayashi, Executive Director for the Hawaii Banking Association, in opposition. Chris Cofield, Executive Director, Imua Alliance, in support. Kathy Lee in support, and Alicia Humiston for the Rental by Owner Awareness Association, also in opposition. That's all the written testimony we have, or that's all the testimony we have. Members, any questions for the Department of Taxation? Okay, let me double check and be sure. See what I've got here. Okay, if there are no questions, we'll go ahead and move on to the next bill. This is SB 28, proposing an amendment to Article 9, Section 5 of the Hawaii State Constitution to require the state to produce enough housing to meet demand. First on SB 28 is Brett Kolbus, Chairman, Honolulu County Republican Party, in opposition. Chris Cofield, Imua Alliance, in support. Kathy Lee in support. Glenn Nagao also in support. That's all the testifiers we have, none of whom are present. So we'll go ahead and move on to SB 29, which is also proposing an amendment. Well, not also, it's also a constitutional amendment, but it proposes to amend Article 9, Section 6 to require the state and its political subdivisions to plan to produce enough housing to meet demand in their management of population growth. First up on SB 29 is Sandra Ching, Deputy Attorney General, with comments. Next is Chris Cofield, Executive Director, Imua Alliance, in support. Kathy Lee in support. Glenn Nagao in support. That's all the testimony we have on SB 29, and none of them are present. So we will go ahead and move on to the next bill, which is SB 133. This requires at least one Attorney General investigator be based in each county in the state. First up on SB 133 is the Attorney General, Deputy Attorney General Landon Murata in opposition. Lee Lord, Acting Mayor, County of Hawaii, in support. And that's all the testimony we have on SB 133. We will go ahead and move on to SB 556. SB 556 specifies that nonprofits with a legislator on its governing board shall not be eligible to receive a grant pursuant to Chapter 42F. First up on 556 is Bonita Chang, Staff Attorney for the Hawaii State Ethics Commission.
Good morning, Chair, Vice Chair, and
Morning.
members of the committee. My name is Bonita Chang, Staff Attorney with the Hawaii State Ethics Commission. We stand on our written testimony in support of this bill, and I'll be happy to answer any questions you may have. Thank you.
All right, thank you. Next up is Giovanni Dela Cruz, Executive Director, Hawaii Office of Community Services and Support. Sandy Ma, Executive Director, Common Cause Hawaii. I think I saw her. Oh, there you are. Go ahead.
Chair.
Morning.
Good morning, Chair, Vice Chair, and members of the committee. We stand on our written testimony and support. Thank you.
Thank you. Next is Lisa Maruyama, President and CEO for Hawaii Alliance of Nonprofit Organizations. Morning.
Hi, good morning, Chair, Vice Chair, members of the committee. We stand on our written testimony and support as well and are available for questions if you have them.
Okay.
Thank you.
Thank you. Next is Banner Fanene in support. And that's all the testimony we have on SB 556. Members, questions? I have a question for the Ethics Commission. Let's see. Ms. Chang, I think it was.
Yes, Chair.
So there's three different groups that are specified in 42F that may receive grants, and it's individuals, concerns organizations that are incorporated under the state's laws and have bylaws or policies describing the activities or services the grant would support, and nonprofits. So this bill as it stands only applies to nonprofits. Is there a reason to restrict it to only nonprofits?
We normally have jurisdiction over, but I guess nonprofits are one of the entities that are eligible to apply for grants. The conflict issue arises more so with nonprofit organizations and boards because officers and directors of the nonprofit organizations have fiduciary duty. So that kind of sets up a potential conflict if a state legislator sits on that board. So I think this issue was specifically to address nonprofit organizations and their governance situations, and not so much with individuals or
Okay.
other entities.
So nonprofit grantees are also required to have a governing board whose members do not have a material conflict and serve without compensation. Yeah, I don't know. Yeah, okay, I understand what you're saying. So for the section B of that part, those three entities that I mentioned that can get 42F grants, is to your knowledge, are some of those for-profit corporations or for-profit entities?
I'm not really familiar with all the ins and outs of the GIA grant process.
Okay.
I don't know whether for-profit organizations are eligible to receive GIA grants. We'll have to take a closer look at that to see if that issue also applies on that end. But normally we don't get that involved in the GIA grant process. It's just we decided to comment on this one issue in terms of in support of the
Nonprofit.
yeah.
Okay, thank you.
Okay, thank
Members,
you.
any other questions? Okay, seeing none, let's go ahead and move on. Next up is SB 662 relating to tax credits, requires that new income tax credits include a 5-year sunset or a gradual reduction. First on this is Department of Taxation, Isaac Choyer as designee.
Good morning. It's Tachiro Ishii for the Department of Taxation, and we stand on our written testimony providing comments.
Okay, thank you very much. Well, that's all the testimony we have on SB 662. Members, any questions for Department of Taxation? Okay, I have a question for you for tax. What do you see as the benefit of a measure like this?
I guess it kind of forces the executive branch as well as the legislative branch to kind of review tax incentives that were established and see if they're still appropriate and possibly whether the amounts are appropriate. And it could go either way. So it helps, I guess, keep the law updated.
Okay.
And current with policy.
Okay. And
but Chair, can I just add to that? I mean, one thing here, and obviously you folks know this, is that like a law can't permanently restrict another law. So like even if this law was to exist and another credit came in and said, well, notwithstanding any other law, here's the time that it's going to be effective. So conceptually it's good, but it's ultimately, I think, something that we need to keep an eye on actively. Like this in itself is not going to, if nothing is said about it in the, for instance, a new credit established, then this law would apply. But if the other law said notwithstanding any law to the contrary, and it gave, for instance, like a 10-year period, that 10-year period would be controlling.
Right.
Right.
Do you, so the way you read this current bill, it only applies to new tax credits. It doesn't apply to tax credits that are existing already.
It says established. So I guess one legal question I don't necessarily know the answer to is what happens when a credit that was about to sunset but is extended before its sunset date? Is that an establishment that would trigger this? So I guess that's something that you may want to consider if you're going to amend the measure.
Okay. Okay. Good point. All right, members, Senator Ocasio, go ahead.
I'm just curious, what is the feasibility of amending this to exempt tax credits that are specifically designed to help low-income residents, so that the sunset wouldn't apply to that?
I think it's possible. It's just a matter of how we would define that. And so that gets a little tricky, obviously, because each tax credit has different requirements or intended to be. So we would want to be as specific as possible when describing that. And obviously, where there is some definitional gaps, the department is authorized to issue guidance as well as administrative rules. So we do our best to kind of see, where that fits in. So for things like that, yeah, you'd probably want to say for individuals only, obviously, because it'd be a credits directed for individuals, and then for generally, we kind of characterize it with a simple term, which is like social welfare or social purpose, and versus tax credits that are done for business incentive purposes. It's kind of the big distinction that we kind of see here. And there's other things, right? Tax credits to offset other fees and so forth. But generally, so I would say at the very least, it would be directed towards individuals and for social need.
Okay, thank you.
Members, any other questions? Okay, thank you. If not, we'll go ahead on and move on to SB 1196. 1196 amends the due date for employers to file the wage and tax statements from the last day of February to January 31st following the close of the calendar year. Imposes a penalty on employers that fail to timely furnish and file the wage and state tax statements. And I believe this makes the state deadline the same as the federal deadline. On this one, first and only testifier is Department of Taxation. Go ahead.
Tachiro Ishii for the Department of Taxation, and we stand in our written testimony in support of this measure.
Okay, thank you. Members, questions? I did have a question. So it is true. Is it true that the federal W-2s they have to be delivered by the 31st of January, and we're just conforming with that practice?
Yes, sir. Actually, it's mailed by the 31st. So for
Mailed
tax,
by the 31st.
yes,
Okay.
for tax stuff, it's the postmark date is what controls. So
Okay.
it doesn't actually have to be in hand of the agency. So in our case, no tax, but in the federal case, the IRS.
But it makes it the same deadline. as the
Exactly.
variance.
Yes, that's
Okay.
correct.
All right, members, any other questions? Can we go ahead and move the pre-specified list of people over into a meeting room for decision making? So I'm sorry, for the public, we're gonna go into for decision making. We're gonna go to I never remember what these things are called. It's not a chat room. It's a what?
Breakout.
Breakout room. That's what so IT, can you switch us over to the breakout room?
Sure thing. I'm gonna go ahead and meet you all and then start the transfer, okay?
Thank you.
Thank you. Chris, Lisa, loud inside. Okay, break rooms are open.
You actually have to hit join.
Yeah, sorry, you're gonna have to join. I'm sorry.
Okay. Okay, coming back in for decision making on today's agenda. First up on today's agenda is SB 18. This would establish an empty homes conveyance tax against certain residential property owners who own a vacant residential unit in the state. I was one of the people who signed on to this bill. I think it's an interesting idea, but I think the testimony indicates that we don't have a finished product yet. So I'm going to go ahead and defer SB 18. SB 28, this proposes an amendment to Article 9, Section 5 of the Hawaii State Constitution, required the state to produce enough affordable housing. This one I will also defer. But SB 29, I would like to move out with an amendment. I'd like to accept the Attorney General's, SB 29 is another amendment to the Constitution to require the state and its political subdivisions to plan to produce enough housing to meet demand in their management of population growth. Recommendation here is to move with an amendment to add as provided by law, which would fill in would allow the legislature and the governor to fill in the pukas about what exactly this would look like and whether we're targeting affordable housing or what exactly we're trying to do. But that would be the proposed amendment. Any questions or concerns? If not, Vice Chair, I guess you're actually in the building and have the hard copies of the vote sheets today. Okay, great. Go ahead.
Members voting on SB 29, the chair's recommendation is to pass this measure with amendments. Chair Rhodes?
Aye.
Vice Chair goes aye. Senator Ocasio?
Aye.
Senator Gabbard?
Aye.
Senator Kim?
Can't hear you, Senator Kim. Okay.
Oh, sorry. Let me unmute myself. Hold on, I'm having,
We hear you.
Hey, we hear you now.
okay.
So
Senator Kim?
Aye.
Thank you. Senator Lee?
Mike. Aye.
That's an aye for Senator Lee. Senator Favela?
Reservations.
Reservations. Chair, the recommendation is adopted.
okay, thank you. Next up is SB 133, requires at least one Attorney General investigator be based in each county in the state. I'm going to defer this. I think the AG is right that it's going to cost more money, and they could do this now if they wanted to, but just to the AG, we're only deferring it. So the bill is still alive, and if I continue to get complaints that the AG's services are not up to par on the neighbor islands, this can and probably will be resurrected. So it's a deferral for now. Next up is SB 556 relating to grants, specifies that nonprofits with a legislator on its governing board shall not be eligible to receive a grant pursuant to Chapter 42F. Recommendation on this one is to pass with some amendments. First, we'll change the terminology existing member of the legislature to current member of the legislature. And we'll apply the criteria that 42F grantees not have a current member to the other two eligible categories, which are individuals and organizations. And then there are certain organizations that are not necessarily nonprofits that can apply as well. Any questions or concerns? If not, Senator Keokolole.
Members voting on SB 556, the chair's recommendation is to pass this measure with amendments. Noting the presence of all members of the committee, are there any individuals with reservations? Any opposition? Seeing none, all members vote aye. Recommendation adopted, Chair.
Thank you. Next up is SB 662. This requires that new income tax credits include a 5-year sunset or a gradual reduction. Recommendation here is to pass with some amendments. First, we'll be more specific. We accept DOT tax amendment to apply it to any tax credit under this chapter that is established after December 31, 2021. I'm sorry, that's DOTAX's amendment. And we'll also be sure that it applies to renewals. So if there's a tax credit that's expired but then is renewed, that would be subject to this as well. And there's also some unnecessary verbiage that we'll clean up. Not really a tech, but it's anyway. We'll take that out as well. It doesn't really change the thing. It doesn't really change the direction of the bill. Okay, questions or concerns? If not, Vice Chair.
Members voting on SB 662, the recommendation is to pass this measure with amendments. Noting the presence of all members of the committee, are there any reservations? Any opposition? Seeing none, all members vote aye. Recommendation adopted, Chair.
Thank you. Next up is SB 1196. This amends the due date for employers to file the wage and tax statements from the last from the last day of February to January 31st, following the close of the calendar year. Imposes a penalty on employees that fail to timely furnish and file a wage and tax statement. This bill makes the deadline the same for the DOTAX as it currently is for the IRS. So the recommendation is to pass with just technical amendments. Questions or concerns? If not, Vice Chair.
Members voting on SB 1196, the chair's recommendation is to pass with amendments. Noting the presence of all members, are there any reservations? Any opposition? Seeing none, all members vote aye. Recommendation adopted, Chair.
Thank you very much. As you're probably all aware, we do have a hearing tomorrow, and it's for the two judges from the Second Circuit plus some bills. So we'll see you tomorrow morning, or probably see you at session too. But have a good day.
Thank you. Aloha.
Thank
Aloha.
you.